Hello everyone. I'm here with Sara Bedin. I'm Marta Coto. We are from LEA Consortium, a project about PCP and PPI, coordinated support action. So we are here to have a brief conversation about the advantages and disadvantages about joint and coordinated procurement, the different types of cooperation between contracting authorities. So, thank you, Sara, for being here. So, let's start. I know that there are different types of cooperation between contracting authorities. What types of cooperation do you think is possible concerning the public procurement?
Okay, we have basically two forms of cooperation. One is called coordinated procurement and is implemented through the preparation of common specification, common requirements for work, supplies or services that will be procured by a number of contracting authorities cooperating, but each conducting a separate procurement procedure based on national legislation and direct and full managed contractual relationship with suppliers. So in this coordinated procurement, each procurer awards his own contract and directly himself. So there are no big implications, no big change from ordinary procedure for contracting authorities, particularly from a legal perspective, because their scheme remain entirely domestic as far as they are concerned. And synergies and economical scope could be determined both for the contracting authorities and the suppliers, but there is not a significant reduction of transaction costs because the number of procedures is not reduced, is the same, because everyone implements their own contract. And so no significant coordination costs occur for what concerns the procedure and the contractual definition, but of course there is a kind of coordination and cooperation in defining the need, the challenge and the requirement. And this is the most light approach. We have a strengthened form of cooperation that is probably more interesting to be analyzed, to be explored, and is called joint procurement. We call it joint procurement. And it occurs when a procurement procedure is implemented by a number of contracting authorities by acting together or by entrusting one of them, one contracting authority, or a central purchasing body also, with the management of the procurement procedure on behalf of the other. So in joint procurement we have two separate approaches that we can call centralized or delegated approach.
Okay, then what about the legal basis? Do you think what are the legal bases for coordinating and joint procurement?
The legal basis for both are in the European Procurement Directive of 2014, both in the preamble, number 71, and Article 38. And this article and preamble introduce the distinction between coordinated and joint procurement, as I exposed. And it defines that where several contracting authorities are jointly conducting procurement procedure, they should be jointly responsible for fulfilling their obligation. Where only part of the procurement procedure are jointly conducted by contracting authorities, this joint responsibility should apply only to those parts of the procedure they decided to carry out together, but each of the contracting authorities remain solely responsible in respect of the procedural part they conduct on its own. For example, the awarding contract, the conclusion of the framework agreement, the reopening of competition, it depends. So their responsibilities refer to the part they conduct together, and they are jointly responsible or separately responsible in respect of the part they conduct they own. There is also another article, the 38 of the directive, that introduces occasional joint procurement acted through the central purchasing bodies, and the provision, it's saying that the provision of centralized purchasing activities by a central purchasing body located in another member state shall be conducted in accordance with the national provision of the member state where the central purchasing body is located. And this article introduced the aspect of the cross-border dimension that is very important.
Okay. So, if we talk about the joint procurement itself, how could it work?
We have two models. One is called joint collaborative procurement. The other is joint centralized or delegated procurement. The first is when one lead procurer only awards a framework contract with lots to each supplier, and each procurer awards a specific contract or many contracts for his lot or multiple lots to the supplier or suppliers, delivering the solution he buys. Individual contracts in this mechanism are settled and made by different contracting authorities through the terms of a framework agreement. In case of joint centralized or delegated procurement, we have one lead procurer awarding all the contracts to all the suppliers on behalf of all the contracting authorities involved in the project, eventually of different member states. So there is a different intervention and level of cooperation between the contracting authorities jointly involved in this exercise.
Okay, perfect. And if you can state the main advantages of the joint procurement, what advantages would you say?
I would say that joint procurement reduces the risk of corruption, given the fact that there is a higher number of parties involved than in traditional procurement procedure. Saying that, I think that the advantage we typically refer to when we consider joint procurement are mainly related to the cross-border and transnational dimension of such a procurement, especially if oriented to innovation, as we are supposed to do in LEA projects. The creation and consolidation of a procurement group who pool their needs, their effort, their demand, and the sharing of the risk associated with early stage innovation can enable the development of cost-effective solutions aimed to cover bigger market challenges and provide mutually advantages and an efficient allocation of benefit resulting from the innovation. So the pooling of the demand determining a win-win situation for all the parties involved from the demand and supply side. Because the demand economic dimension is, if is actual through a PPI or potential through a PCP, have a major impact on the result of the project, since bigger is the market where companies could sell their product, the lower is expected the price for procurers and user of the final product. So there is this dimension to be considered.
Okay, so then you can say that joint procurement could change the market structure, strategy, and also pricing?
Absolutely, yes. And also streamlining desired solution specification among different procurers and covering a cross-border demand at the stage where solutions are still under development, empower procurers to foster the necessary degree of standardization, interoperability, interchangeability, avoiding lock-in, breaking down the barriers to the adoption of innovative products and services linked to the historical and domestic prerogatives. So it's not just an aspect related to the cost, the reduction of the cost, but it's also the new functionality and new performance you can achieve through a cross-border initiative that could be defined. And another aspect is related to the competition, because if it's cross-border, the procurement could multiply the effect of competition, since a higher value of procurement contract is expected to attract higher competition, including suppliers from other member states.
Indeed. Legal provisions are oriented to ensure equal access for suppliers in the member states, so there are no restriction of competition, right?
Yes, we can say that joint and cross-border procurement force the buyers to think Europe rather than local, and using enabling maximization benefit from the potential of European single market. And those benefits would include economies of scale and risk-benefit sharing, not least for innovative projects involving a greater amount of risk and uncertainty than rationally bearable by a single contracting authority. So in innovation is quite crucial to have a cross-border approaches.
Okay, so now we are discussing about the advantages,
Yeah.
but what about the barriers, if there are any of these different approaches?
I think that in the two models we have considered, but especially when the joint procurement is conducted through a centralized approach, where there is one lead procurer acting on behalf of others, we have a potential reduction of transaction costs, because there is an aggregation of procedure, so a reduction of the number of procedures. At the same time, in the balance, we have to consider the coordination cost that for sure will increase, and there is a complexity due to the coordination that has to be considered and potentially could balance the advantage of reduction in transaction cost. There is a particular need for coordination between administration involved, and this implies public-to-public cooperation and delegation relationship before they can enter into and call off within a framework agreement contract. And this mechanism of inter-administrative cooperation between contracting authorities, eventually in different member states, cooperation between contracting authorities and central purchasing body, typically don't coexist, has to be developed ad hoc, case by case, in support of this kind of procurement. This takes a lot of time, specialized expertise, because there is a need to establish international public-to-public institutional relationship, which raise several issues of international public law, constitutional law, administrative law, applicable in the member states involved, rather than contractual law. So contractual law is not sufficient to cover and solve these aspects. We have to think about administrative law and different jurisdictions. In some states, we have a completely unregulated relationship, definition and framework. In some member states, we have no formal requirement. In other member states, these aspects are strictly regulated, like in Italy, for example. So there are administrative laws that regulate how two public or more public authorities could cooperate and act. It's very difficult to conceptualize this aspects that involve many issues. For example, how the funds are transferred, how the payments occur, how the invoicing has to be done, and different level of definition. Another complex area, in my opinion, is something that I have seen in the practice, is that concern the e-procurement tools and platforms that are designed for national procedure and fit national regime, national fiscal regime, and are typically based on national language only. So there is the need to define what e-procurement platform could be used for the specific joint procurement exercise. And so there is a definition before implementing this kind of action that is quite complex.
Yeah, I know. So the legal provision derives from the EU directives seem to expect a lot from joint public procurement procedures without exploring the additional consequences deriving from the perspective of cross-border procurement, right?
Yeah, the article opened the way to the implementation of joint procurement, opened the way to the exploration of various ways, the several layers of legal provision involved, interplay and which opportunity they can provide to achieve the goal, that is enhancing competition, efficiency in public spending, but are way to be explored, to be investigated, to be defined, to be settled case by case. So is a barrier to be overcome.
Yeah, I completely understand. And now, if we specify for the LEA case, what do you think? What about the LEA PPI and PCP perspectives?
Okay, for PCP, I have no doubt that the joint procurement and centralized and delegated approach is more convenient because research and development need to have a cross-border integrated demand, because this investment has to be shared and it has to be predetermined the future standards and the condition to have a very efficient and open market without foreclosing competition. So for PCP, no doubt. For PPI, that is more complex because we have to follow the national procedure, we have to follow also the national legal framework. We can say we are facilitated a little bit, if we can say this, by the fact that LEA challenges concern learning technologies, so software basically, and this domain is suitable for joint procurement due to the no complex or less complex delivery process in the software domain. Apart this, we are discussing in LEA, as you well know, to prepare some joint cross-border PCP and PPIs also under the framework of Horizon 2020 funding. We can say we expect that working under Horizon 2020 framework could provide us a workable, functioning models, templates, which economic operator and contracting authorities need to make practice, to start to make practice. We have not other experience at the European level about learning technology or technology in school. So it's a sector, it's a domain to be explored, because we can also find some specific regulation concern education matters. But it's a learning curve that we are engaged to pursue, and we are engaged to invest in.
Yeah, I would say the same. It's a learning curve to be pursued, at least for this moment. Well, I think for now it's all. Thank you to listen our brief discussion. We expect some questions for you if you have any. We are more than welcome to help you together with the other members of the consortium. Saying thank you.
Thank you very much.